On to a story that made the headlines tonight. Now, former President Chandrika Bandaranaike Kumaratunge says a government that believes that the judiciary must act according to its will and whims bodes serious danger to democracy and people's freedoms.
A document authored by former President Chandrika Bandaranaike Kumaratunge on democracy, the state and the judiciary goes on to list a series of incidents that mounted pressure on the judiciary, including the impeachment motion against Chief Justice Dr. Shirani Bandaranaike. In her document, former President Kumaratunge states that in the intolerant political environment that prevails today, judicial decisions unpalatable to the government are not tolerated. A dismissed workman has several institutions to seek justice from, but under the J.R. Jayawardena Constitution, judges of the Supreme Court and Court of Appeal, who constitute the highest authority that dispenses justice to all, have nowhere to go if justice is denied to them. The document adds that her government's proposals for constitutional reform in 1997 and the 2000 draft constitution bill that were presented to Parliament provided for an inquiry of a judicial nature to be held outside Parliament when a motion for impeachment is presented against a judge. However, in the case of the Chief Justice, the inquiry under the draft constitution was to be held by a committee consisting of 3 persons, each of whom holds or have held office as a judge in the highest court of a Commonwealth country, or who holds or have held office as a judge of the Supreme Court or the Court of Appeal. The document further notes that the draft constitution of 2000 did not become the supreme law of the land due to the inopportune actions of the UMP. What is surprising today is that a government led by the Sri Lanka Freedom Party has thought it fit to follow the Jayawardena Constitution and the standing orders passed during the Jayawardena administration, rather than amend standing orders or bring in legislation to provide for an inquiry of a judicial nature as envisaged by the draft constitution of 2000, a bill presented by a government led by the SLFP. The document adds that during her People's Alliance regime, the judiciary ruled against the government on several instances, yet the judges were not impeached on grounds of breaching parliamentary privilege. A judge may or may not perform to the expectations of the appointing authority or of the people, but judicial decisions need to be respected by all, especially the government. The institution known as the judiciary has grown through the ages to guarantee individual freedoms and a properly functioning, humane government. The concept of separation of powers guarantees that the 3 branches of state, parliament and other elected bodies, the executive and the judiciary, have the power and the ability to function freely and independently of each other's undue influence. The concept of separation of powers has proved to be a most essential cornerstone of democratic governance.